to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements, is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning, as of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And to add the notice to admit.
Yes, but my Lord, it can affect the issues. In fact, your Lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Chikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements,
yes,
which are limited to.
You are call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now today until tomorrow in order to prepare witness statements.
Mr. Jikata, this should have been prepared already.
No. Well,
these statements should have been prepared already.
Well, that is not correct. Maybe your Lordships,
Mr. Jikata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day. And you said you were with only Mr. Luther. And you were recorded as such. But Mr. Ayine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your Lordships have made the orders already, And we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's a 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court.
Please, resume your seat, please.
Lords, we are most grateful.
All right. Let's go.
2021. That's exactly what happened there at the Supreme Court. And what was to take us through it after that, we'll engage our guest, Dr. Kwekwa Jimanbudu, who is a lawyer. He's a law lecturer and the head of Law Center's Gimpa Faculty of Law, for us to explain one or two things. But before that, let's go to the Supreme Court and join Abdul Hai Mumin together with...
Team lawyers had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable course of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint or the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
And the issues are brought back, that it could take all of us back to the very beginning of matters.
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Please. It's okay.
It's not working.
It's okay.
Yeah, Gordon.
Yes, what is the, are they going to ask?
No, I think you just go ahead and greet them and then.
All right. Good morning.
All right, Counsel, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel for the second respondents think that they're not well prepared for this trial. They seem to raise objection to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us, that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have brought the petition to court. What does it mean for putting together a solid case to put across your court?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court. We wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make?
Well, we are yet to, I mean,
Serve the order.
we are yet to be served the order. We are now going to look at, because it was just read to us, we need to now sit down and look at it. Did it? Because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Counsel, your colleague, Dr. Ayeni, was remanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get two versions?
Yes. Baba Jamal. Yes.
Yeah. This one, you are dealing with your friend.
Yes.
Your friend.
Mr. Ene, once my boss, I have a specific question. Which one?
What has accounted for the inability of the plaintiff?
No, it is not the inability of the petitioner to bring witnesses. All right, we had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay. Now we thought that at case management, at the time of case management, which is 5 days of, okay, a 5-day timeline granted by the court itself in the new rules. Okay, we thought that we should be in a position, okay, to plan together with the other parties on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the witness statements, by noon of tomorrow. So it is not about us, it is about the tight that are being given by. And I think that the court is being very unfortunate. When you have indicated that